Hey everybody, Crab and Cuz coming at you. Hey, you know who these two guys are? Let's talk about Alex Murdaugh right now because they just filed their final response and reply to the South Carolina Supreme Court, and now it all sits with the Supreme Court. Let's get into it. So the Attorney General's office in the Alex Murdaugh trial says that the comments that Becky Hill said were fleeting and foolish. Okay, well then arrest her. But they said ultimately they were harmless. But the defense, Jim and Dick here, they counter and say that these constitutional protections were shredded in ways that demand a new trial. I agree with them. I'll tell you why. So we've got two cases to look at. The first one is Rimmer. That's the law of the land when it comes to jury tampering. Rimmer versus the United States, and that was in 1954. The United States Supreme Court held that any any private communication with jurors about a case is presumptively prejudicial. That's it. Makes the burden of the state to prove harmless. But the state went and they leaned on a case called Smith v. Phillips in 1982 in the United States for Orlando to argue that prejudice must be shown. Bah. Those cases involved indirect or speculative concerns, not a court official giving jurors merit-based guidance. And then their reply points, and I might say correctly points, to this case called Parker and v. Glad in 1966, where a bailiff simply stated that guy's guilty, and that led to a reversal. Let's not get into the weeds too much. The other things they talked about, financial crimes, they were stretching beyond recognition on these things, post Miranda silence, or Murdaugh wasn't talking, and then the state says, well, he wasn't talking, he must be guilty. They threw that out. The expert testimony, the iPhone waking up, that guy, throwing it, the tool marks on the shell casings, bogus. I've talked about this ad nauseum. It's junk science that the state put up. The unrelated weapons that weren't even his involved in the case, the bringing out, these things in the trial, the blue raincoat, which never should have gotten in. Here, basically, it comes down to this. Comes down to this. When constitutional guarantees of an impartial jury and fair trial collide with evidentiary overreach, the law always favors strict protection of the accused, a la Alec Murdaugh. Rimmer and Parker stand as bulwarks against the official interference of jurors, and that's it, in my opinion. Dick and Jim did a great job. By the way, stick around because I got one more thing to show you. Dick and Jim did a great job. Everything is now at the Supreme Court. If the Supreme Court wants to hear oral arguments, they can. If not, they can take these written motions and make a decision. Uh, Last thing I'm going to leave you with Ted Bundy. Ready? This guy, Mark Tinsley, remember him? No, Tinsley the Tiger? Well, he referred to Alec Murdaugh as Ted Bundy. It's the most ridiculous thing I've ever heard anybody say. He has no idea who Ted Bundy is if he's making that comparison. And if he did it for show, well, then he did it for show. But I hope he knows who Ted Bundy is. But making that comparison, he doesn't know. Cask.